Well, thank you, Ingrid, for this introduction. And I think when our distinguished conference organizer of this fabulous event, Boris Babic, asked us to speak on the topic of due process, and we prepared this topic, we knew that we would have to boil it down to some specific aspects and some specific interesting issues. Otherwise, we could fill maybe a conference on its own. And we agreed in our preparation that one of these hot topics, which might be that hot even that we feel it in this room already, is the question of access to the file, the question of, to be precise, to which extent should a third party claimant, a potential claimant of private enforcement measures, get access to the files of the Commission and the national competition authorities and maybe also the national courts. This is a very important question. Ingrid already mentioned it, because I think it's fair to say that you all know that the leniency application system, ever since it was introduced in the end of the 90s by the European Commission, then also by most of the national competition authorities, has been proved to be the most effective weapon in terms of cartel enforcement altogether. So, on the other hand, we heard in the last panel that there is an increased activity also in terms of private enforcement. Private claimants are trying more and more to get damages from the infringers of the EU competition provisions. The Commission made clear in its white paper on private antitrust litigation that the Commission wants to build up private enforcement definitely politically as a second pillar of competition law enforcement in Europe, driven maybe also by the positive development in that respect in the US. So there is definitely a certain dilemma now for the Commission that on the one hand the Commission wants to maintain public competition law enforcement on the basis of leniency application, but on the other hand the Commission wants to enhance private litigation. And what is very important, as we heard already before, for a private litigant is, because in most of the national laws, the national civil laws, it is the burden of proof. The burden of proof rests with the claimant, is to get his hands on sufficient evidence that at least the infringement has taken place, and also, of course, that there is a causal link between the infringement and the damage that has been occurred. So what I want to, and I promise to be short, I want to give you a short overview on the legal aspects in that context. Very briefly, the legal framework explicit to access to the file in competition law cases doesn't really tackle the issue of third-party access. It's more related to the question to which extent the defendant has a right to access to the file. The specific regulation 1/2003 in this respect and the other legislative acts, they just say basically that not even the complainant has the right to access to the file. So if you look at the specific legislation here, there would not be any right for a third-party private claimant. And the Commission has made it very crystal clear in its white paper that especially when it comes to leniency application, to the corporate statements, to the confession of the leniency applicant that he has actually committed an infringement of Article 101, that the Commission wants to safeguard, to protect these corporate statements from any access by third parties. Nevertheless, it's not surprising that private plaintiffs do not actually accept these Commission positions and have tried in various ways to get access actually to the Commission files. There are basically two routes which are possible. One is directly via the Commission, and one is via national courts and national competition authorities who got hold of records of the Commission files. If we look at the first possibility, the access via the EU Commission, what was the legal basis, or what is the legal basis still when a private plaintiff tries to get access to the Commission's file and also to the corporate statements? It's basically the transparency regulation, the general transparency regulation 1049/2001, which says that all documents that all documents of EU institutions should in principle actually be accessible to the public. And private claimants try to invoke this regulation also when it comes to access to the competition files of the Commission. The Commission tries to protect its file, as I said before, and there have been various judgments by the General Court, but also by the Court of Justice recently. When we look at the General Court's decisions, I mentioned two of them, VKI and Edition Odile Jacob, I guess it's to be pronounced. We can generally say that the General Court didn't really support the Commission's position here. The General Court said that if the Commission wants to rely on an exception of the access to the file according to Regulation 1049, she has to first carry out a concrete and individual examination of each individual document that the Commission wants to exempt. So the Court was here reluctant to actually restrict the application of Regulation 1041. Nevertheless, in the recent judgment DGI, which was a state aid case, the Court of Justice seems to have developed maybe a new doctrine in a way that the Court said if there is an explicit procedural rule which governs the Commission's activities in a certain area, then, and if these procedural rules do not provide for access to the file for third parties, then Regulation 1049, the Transparency Regulation, would not be applicable at all. And one could argue now, of course, that on the basis of this case, that since there are procedural rules laid down in Regulation 1 for the Commission in cartel cases, that there is room for argumentation that the Transparency Regulation is not applicable to competition cases, but we will see whether this will be really applied to competition cases. There are several other cases pending before the European Court of Justice at the moment in this respect. We will see what the outcome will be. In that respect, another judgment is worth mentioning. It's the Postbank judgment, which basically said that the Commission does not infringe the treaty if the Commission gives a third party access to its file based on reasonable grounds. In that case, it was that the Commission provided access to the statement of objections in a case to undertakings which were summoned to participate in the oral hearing, and the Commission wanted to give these two undertakings the chance to get prepared for the oral hearing. And those two undertakings then used this evidence in a private litigation in the courts against the defendants of the Commission case. And the European Court of Justice said in that respect, I think it was again a referral procedure, that the Commission is entitled, actually, it does not breach the treaty when it gives access to its file under certain circumstances and does not expressly prohibit the undertaking that gets access to the file to use this evidence in private courts. So what we can derive from this judgment, if a private plaintiff, via any route, via the Commission or via national courts or via a national competition authority, gets access to the Commission's file, then he can also use it in private litigation. The extent, however, to which that is possible is still, to which this access is possible, is still rather unclear. I'm coming back in a second to this already several times today mentioned judgment in the Pfleiderer case, which was supposed to shed some light on this issue, but it finally didn't. Boris, to make our